Britney Spears told a Los Angeles court Wednesday that she is, quote, traumatized by her conservatorship. The pop star has been under the court-mandated arrangement with her father, Jamie, since 2008. She's now fighting for more control over her life and finances. Lilia Luciano has the details.
What do we want? Free Britney!
With supporters outside, Britney Spears spoke to a court for the first time publicly about her conservatorship, making bombshell statements about the rare arrangement under which her father, Jamie Spears, legally controls much of her life.
Conservatorship has got to go! Hey, hey!
The singer told the court she wants her life back, wants to end the conservatorship, and that she didn't know she could petition the conservatorship to end. Spears compared the situation to sex trafficking and said she's not here to be anyone's slave. The conservatorship began in 2008 when there were concerns over her mental health. A recent New York Times investigation found that Spears expressed serious opposition to the arrangement years ago, saying that it restricted everything from whom she dated to the color of her kitchen cabinets.
So it's really rare that someone like Britney Spears, who's been able to actively perform and make millions of dollars, would be under a conservatorship.
Lilia Luciano, CBS News, Los Angeles.
For more on this, I want to bring in Carolyn Reinach Wolf. She is an executive partner and director of mental health law at the firm of Abrams Fensterman. Carolyn, as we heard, Britney Spears called her conservatorship abusive, likening it to sex trafficking. She even said that she wants to sue her family. Could we see her comments make an impact on this case, and could she be able to sue her family?
It would be unlikely that she would be able to do that. I think that's kind of it's extreme statements to make about a conservatorship. Conservatorships, or guardianships as they're called in some states, are very tightly overseen and controlled by a court. She went before a judge reviewed the evidence and certainly made a judgment and a decision based on the evidence that was presented. So I think her words are a bit extreme. And if she wants to have the conservatorship discontinued, it's going to be based on the facts that she presents to the court. Is she ready to have the conservatorship discontinued? Do the facts of her life situation currently warrant discontinuing the guardianship or conservatorship, and so on?
She also said that she is not empowered to make her own reproductive decisions. Is this extremely unusual for an adult woman?
Yeah, most guardianships or conservatorships really don't have that kind of power included in them. So that would be very unusual for a court to grant an overseer or a conservator that type of power. Again, those decisions would have to be made by her personally, and if they couldn't be made by her personally, then you always have the option to go back to the judge and to the court and to make your arguments based on, the facts as they're presented.
Britney Spears has been under a conservatorship for 13 years, but her lawyers say she's never contested it before. She says she didn't know that she could petition to have it removed. Why is that? And is that right, that she shouldn't be aware that she had that ability?
That would be unusual. Generally, lawyers will counsel their clients about the ability to discontinue a conservatorship, what the criteria would be to discontinue a conservatorship, what the facts are currently, whether the lawyer believes they have a good case at that time and should go back in and ask to discontinue the conservatorship or the guardianship. So it would be unusual for a lawyer not to counsel a client about that option. Sometimes lawyers will wait to go back into court because they don't feel their client is ready to present a good case to the court, is not ready to back up their argument by the facts that they have in front of them. So that certainly could happen, but it would be unusual not to counsel a client as to the ability to go back into court and to ask that it be discontinued.
Let's talk about what kind of uphill battle this might be. How common is it for a person to be released from their conservatorship?
It's not that common, but of course, each case is different on its facts. And once you have the facts on your side, then we counsel clients to go back in and make an application. I've found over the years that actually it gives incentive to the individual who's under conservatorship or guardianship to really get their affairs in order, to stay in treatment, to manage their bill paying or their finances as much as they can, in order to go back to a court and show the court, look, I no longer need to be under this conservatorship or guardianship. The legal burden actually shifts from the original petitioner in this type of application to show that the person lacks capacity and needs someone to manage their affairs. And then that burden shifts to the individual to show a court they no longer need this, and to ask a court to discontinue it. So again, based on the facts, there is a very good opportunity that a court will allow to go back in and say the person no longer needs this type of oversight or supervision.
Carolyn Reinach Wolf, thank you.
Thank you.